There we go. And as always, if you'd introduce yourself and with your name and your affiliation to the committee and address your comments through the chairman in all cases, we're happy to welcome you, Chris Merrill from the Equality State Policy Center.
Thank you, Mr. Chairman. As you said, I'm Chris Merrill. I'm the Executive Director of the Equality State Policy Center. I hope you can hear me okay.
We can.
I was watching on YouTube, so I don't know how far back in time I was lagging, but I believe I missed the discussion, unfortunately, about the inclusion of the judicial branch in this bill. So I'm at a bit of a disadvantage there in terms of what information was shared about how it ended up being included in this bill. So my apologies, but I was tuned in.
Mr. Merrill, why don't we just take a minute and catch up on that? That was Madam Co-Chairman's comment here a few minutes ago. Do you want to repeat that?
Certainly, Mr. Co-Chairman. I think that the comments from staff from LSO, I think, are important for us to consider. And as we consider those comments moving forward, I just wanted to have my recollection refreshed as to how it was incorporated into and what our concerns were in order to find it there within the bill draft. And so I'm neither for nor against it. I'm really just seeking information and how did we put it there and why is it there, and understanding those concerns and those motivations as it relates to some of those constitutional pieces that we need to be mindful of. So I apologize, but I don't recall a robust discussion about its placement there.
Okay, Mr. Merrill.
Mr. Chairman, appreciate that. As to the question about separation of powers and including the judicial branch, that question makes me wish I had gone to law school. But I would like to, I guess, approach it as a layperson, if I may, and just when I was thinking through this, the thoughts that occurred to me were this: basically, you take a step back. What the legislature would be doing here is saying, if you are a public official, it's important that you are ethical and you don't use that position unethically, corruptly for personal gain. I mean, that's part of what this bill would do. And it seems appropriate to me in that sense that the legislature kind of set the standard for what we see as the ethical use of a public office. Now, as for how that would be implemented or how best to carry out that vision of the legislature, it seems like the legislature is the place where the norms and ideals are incorporated into law. So again, that's a layperson's interpretation. Also, the separation of powers is not absolute, right? Each branch of government is not, a quasi-independent government in and of itself. There are powers that are given to each branch, and as a patriotic person, I think those powers should be guarded jealously. But they're not given absolute power, and so I do think it's appropriate for the legislature to consider how these public officials, including in the judicial branch, should conduct their business. So again, I'm not a lawyer, but that's just a layperson's take. If I may, I'd like to move on to a different topic in the bill.
Please do.
So just a real quick technical point. So in the draft that I downloaded, I don't know if this was updated since, but I'm looking at working draft 0.4. At the end on page 14, we still have this section here, 913-106, official decisions and votes. And then I believe that was moved entirely to page 8, the bottom of page 8. So we might have a little repeat language there. But I just might be confused, but that's just my observation of this draft.
Mr. Chairman, if I may jump in
Please do.
for a minute, just to clarify. On page 8, those changes to 913-106 are the changes to the intro subsection A. On page 9, if you'll notice, that last sentence that leads into the colon is stricken. And then on page 14, that just simply shows that those 2 paragraphs that follow are being repealed in this bill draft. So the upshot is that the amended language in subsection A will stand by itself without paragraphs handled out from that.
Mr. Merrill.
Thank you, Mr. Chairman. I guess the other upshot is that I was confused. So thank you for that clarification. I'd like to look at the language on page 9. This has to do with official decisions and votes. Page 9, lines 3 through 12. This draft includes this language. In determining whether he has a personal or private interest in a matter, the public official shall recognize the importance of his right to represent his constituency and shall abstain from voting only in clear cases of a personal or private interest. I guess my question for this committee is that strong enough, or is that too squishy? Just again, as a layperson, it seems maybe we could make that stronger or clearer. You know, I somehow got muted there. As a point of reference, my original proposal, and I'll read some language from that. I'm not reading this to suggest that it's better or it's the perfect way to go, but just as a point of comparison. I have this language. A conflict of interest shall exist when a member of a legislative body, public official, or public employee has a substantial financial interest by reason of ownership of, control of, or the exercise of power over any interest greater than 5% of the value, blah, blah, blah. And the idea behind that was to try to get at the concept that although you may be part of a class of people, a larger class of people, you might be casting votes in the legislature that have the potential to benefit your financial interests, your personal and your family's financial interests greatly. And so my hope is that this committee could have a good conversation about that, and if there's a way to get from the language that's here to something that tries to capture that concept. And so you've seen the language I've proposed, but there might be a better way to do it, but that's the concept, Mr. Chairman.
Anyone want to interact with Mr. Merrill on that thought? Representative Washington?
Thank you, Mr. Chairman. My question for Mr. Merrill has to deal with the separation of powers question. Are you familiar with any situation where the judiciary has failed, in your opinion, to properly administer the ethics of their members that would suggest that the legislature needs to intervene at this juncture?
Mr. Merrill?
Thanks, Mr. Chairman. No, I am not, but that's definitely not my bailiwick. There are, I'm sure, people on this committee who are more familiar with that branch of government, but I personally am not.
Representative Stiff?
Mr. Chairman, thank you. Mr. Merrill, I wanted to see if you could address an example to see if I understand where you are on the spectrum of what you think should be legal or illegal. Let's imagine you have a legislator who's also a teacher, and the bill proposal is to have a 10% increase in the block funding grant model across the board, obviously, and say, assuming that 70% of a school district's budget is salaries, you know, that can be expected to positively impact that individual legislator who's also a teacher, their salary, okay? But it also obviously affects a substantial class of people, you know, not 8,000 teachers plus all the other employees. Do you think in that case that is misuse of office for the teacher to vote for that increase in school funding generally? And I think the answer would be no. But then if that's the case, what if the proposal were to have a 10% increase in teacher salaries, for example? Do you think that should be against the law? I'm just trying to get a sense for where you are on what the right policy should be. Thank you.
Mr. Merrill?
Yeah, Mr. Chairman, I think that first of all, I agree. In the scenario you outlined, Representative Stith, the teacher should be able to vote on that bill to increase the block grant funding. And that was why I proposed a focus on a private interest and ownership of a business that stands to gain substantially from legislation, as opposed to just something just like a general blanket statement about you potentially could benefit from it. That's what I was trying to get at. There was a private business interest that you have as a legislator, and that private business interest stands to gain by passage of legislation. Then I believe you should abstain.
Okay. What else, Mr. Merrill?
That's all I have for you today, Mr. Chairman. Thank you very much.
Any further questions for Mr. Merrill about the bill, about his ideas? All right. Well, stick around, and thank you for your testimony. And we'll go now to County Attorney Barron, who comes to us from the shadow of Devil's Tower. And welcome again, sir. And please introduce yourself to the committee and address your comments through the chairman, and away we go. You're on mute, Mr. Barron. There you go.
Thank you, Co-Chairman Kirkbright and Co-Chairman Nethercott. My name is Joe Barron. I'm a county attorney in Crook County, Wyoming. I've been the elected county attorney here since 1991. And prior to that, I worked as a deputy county attorney for all but 6 months in that office since 1986. I've been involved in criminal prosecution during that entire time. And so that's where I come from on this. I'm also represent the county and several of its entities, such as Library Board, Fair Board, Wheaton Pass District, in civil matters as well. So what I've been involved in using and looking at this particular statute since it was passed, and I brought forward these comments and tried to clarify some things, organize it, things like that. One of the things that I heard here, since you guys started early, I didn't hear the whole conversation, but the first thing I heard was whether this should apply to the judiciary and or not, because of a separation of powers issue, that sort of thing. First of all, criminal law has nothing to do with separation of powers. Separation of powers is who administers what. The legislature determines what the law is and what the people have to follow. And obviously, judges aren't special. No person's above the law. That's passed by this legislature, and that's it. And there's mention in here of the Commission on Judicial Conduct and Ethics taking action against a judge, a sitting judge. I've had that experience. My office had a sitting judge at the time that was charged with a DUI and possession of controlled substance, and had to practice in front of that judge while those charges were being started. So what happened there was this. As a practical matter, I'll let you know how this works out, how this played out with the Judicial Commission on Ethics. And essentially, I had to contact them that this was going on. Nobody else did. They don't have any active monitoring. Somebody has to report things to them. And then I asked them, okay, you guys need to begin your process to do this, to remove this judge that's sitting in here that's charged with these particular crimes. The net effect of what happened in that case was simply this, is that all they did was suspend the individual judge who was a justice of the peace at the time, which would be treated no different than a circuit judge or a district judge or a Supreme Court judge. They suspended the individual with pay, and they let the criminal process run its course. And I had a special prosecutor come in because initially nobody would remove the judge from practicing, me practicing in front of him. Well, at the same time, our office was prosecuting him. So to deal with that, I had a special prosecutor appointed to get that done. And so what the Judicial Commission did was they waited until the criminal process was completed before they actually took action to remove the particular judge in question after he was convicted of those two charges. And so to say and rely upon the Court Judicial Commission on Ethics to do anything, you know, they want to know, these were misdemeanor cases. They want to know, you know, what's going on, what the process is. And that, as a practical matter, is what occurred when it came to criminal violations of the law. In the statutes, what on page, let's see here. Page 12.
Mr. Barron,
Yeah.
could we address a question here? Madam Co-Chairman has her hand up.
Thank you, Mr. Co-Chairman. I agree with you 100%, Mr. Barron, that no one in the state is above the law, and judges and attorneys and everyone should be subject to the criminal code. And as your story indicates, they were, and that individual was arrested. A judge was arrested, charged, and prosecuted, sounds like with a conviction for those crimes. And so, you know, check that box, right? They weren't above or evade the law. Now, the process associated with whether or not that judge should have recused themselves or the commission should have acted faster to remove them temporarily, at least until they had the availability of due process as well in their administrative role. I mean, that certainly deserves review and attention for what that process looks like. That said, I don't know that this bill draft would address that particular conduct or is really driving at that particular piece of a judge getting a DUI. So, you know, kind of to speak with that story, and I don't want to cross purposes and intentions here of those concepts.
And Mr. Barron, Representative Gray also has his hand up here. Since we've stopped you, we'll hear from him. Representative Gray.
Well, I want to provide my own response to that question at some point or make a comment, but I think it was directed to Mr. Barron, so he can go ahead. Thank you.
Okay, back to Mr. Barron.
Thank you, Co-Chairman Kirkbride. And to respond to Co-Chairman Nethercott's, what I was explaining was the process that I had experience with the Judicial Commission on that for and what they were doing is exactly right. They were giving the judge the due process to determine if he was going to be convicted. Then after that conviction was entered for those particular offenses, then they looked at that, and then they looked at their standards, their judicial standards, to determine whether or not he should be removed or not. So that's a separate decision. The same thing occurs within these statutes here on page 12, is that in subpart B on line 19, is that a violation of provisions of this act, which is a judicial or the Government Ethics Act, constitute sufficient cause for termination of the judicial officer from his position in accordance with law. So this does not, and this statute does not remove anybody from their job or remove anybody from their position. What it does is that when it says in accordance with law, there are statutes for removal of judges, there are statutes for removal of legislators, there are statutes for removal of elected officials. I tried to list out initially in the initial draft several statutes that were available, and the LSO changed this to in accordance with law, and I understand why, because there's a number of different removal statutes that are out there. So there's still additional due process that is provided to any and all of these folks to do that. Now, I would say this, if they're, say, a county employee and they're an at-will employee, then that elected official or whoever their person that hires and fires them could then terminate them as an employee at will. And they might do it before this as well, but that process is still available for all the elected officials in the state on that. If I've sufficiently addressed that, I have a couple other things I'd like to go over.
Yes, why don't you proceed?
Okay. On page, let's see here. On page 5, line 24, I note that between the word remote and in the original language of the statute that was moved over to here, there was a semicolon there. There is not a semicolon there now. And because it used to be in that there were two parts to that, there were part I and part double I. And given the fact that either somebody that's an English major, to make sense, they need to make sure that we're not changing the intent of the law and the statute by either leaving in a semicolon or leaving it out. And maybe there needs to be a comma there. I don't know, but I do know this, commas and semicolons are important and in the law. And so I think that was in on page, let's see. Let's see if you can. Yeah, if you look at page 14, lines 26 through 35, that's the language that was moved into the definitional sections on this. And in that case, it was remote, semicolon, and then subpart 2, it was set out. Maybe this needs to be set out as rather than I and double I, maybe it needs to be the next thing, which would be A and B. Something to clarify that instead of saving an extra line here is just put that after means, put a colon and then put an A, an interest, and then put the semicolon back after remove the and then indent and put a B, that's lowercase b, after that on the next line down there. So it mimics the language in 913, 26 through 35. So then my next comment on the draft.
Mr. Barron?
Pardon?
Mr. Barron, may I interrupt? Representative Stith had a question. maybe pertaining to what you just said, Representative Stitt?
Mr. Chairman, thank you very much. Mr. Barron, can you give an example of how that syntax change would make a difference?
I don't know, but I can tell you that, excuse me, Seth, Co-Chairman Kirkbride, Senator Thist. I can tell you this, is that I don't know in this particular context how it make a difference until I get into the meat of it and actually think about it a lot. But I can tell you this, that in the recent legislation in the larceny statute, the legislator left an or out of the subparts in that statute, and it has it caused a lot of concern trying to figure out, and frankly has negated a lot of the intent of that particular statute, the way the larceny statute is written when an or was left out of it. So these things had a meaning at a time. I don't know exactly what this will do, but you know, where you got a big long sentence there and you have a lot of conjunctions in there, it's a lot better if you will set these things out so they're easy for people to read and figure out this and that. We've got an and in there, we've got an or in there, we've got another or in there, another or in there, and not one comma. The other matter that I had on this was on page 7. And I talked to the folks in the association, County Attorneys Association, about this. And one of the discussions that we have, and something that I think was brought up in the legislature at the last hearing a little bit, and on page 7, line 6, it says a public employee shall not supervise or manage a family member, ... It would seem to me it's similar to what was brought up before by Mr. Merrill, is that the question comes up in our case is, what does supervise or manage mean? And what does that look like? And we talked about that to try to figure out, you know, how, because you get, what you have is you have a sheriff that can hire and fire, and then you have other people in the office. In my office, it's real simple. Everybody works for me. You know, they work directly with me. I directly supervise them, and I manage all the people in my office. In a sheriff's office, for example, they have layers because they have more people. They have somebody that runs a jail, and they have somebody that runs a patrol, and they have somebody that runs the office and things like that. And they may or may not have hiring and firing capacity. They may or may not, all kinds of issues arise. But I think it would be good to have something within that statute there, a definition as to what does supervisor manage mean. I don't recall exactly what the issue was in the legislative side on their rules, but I think that would be helpful to folks. And I thought about it and just say in a separate section, supervisor manage would mean the ability to hire and fire an employee. That, just a thought, I think that might be something, I don't know. It's just some gray area that people try to get around, frankly. And if you define it, it'll be less likely to be get around it. Then just a comment on what Mr. Merrill indicated on page 9 concerning the 5% value matter. I think that's because the way this statute is worded here, the first thing that popped into my mind was, you know, some elected official that's married to a teacher. And they're voting for teacher salary increases or whatever, whether you're on the school board or whether you're on, um, in the legislature on that. And it would be good to have a black and white standard in there. There's people say the legislature is going to decide to raise the lease rate for state lands. You know, that might increase to go to fair market value, might triple the cost of state leases. And so obviously it's going to have the effect on some legislators, but none of them have 5% of the value of the entire picture. So that 5% I think needs to be quantified, kind of like the question that came up before with the teacher, is 5% of the value of the entire thing that you're voting on, because you guys will get a fiscal note on that. They'll say this change would increase revenue, you know, $20 million, or it would decrease revenue X number of dollars. And so that would be an easy way for a legislator or whoever's in that particular position to know where the line is in the matter. And I think this also goes back in the background here is this, and it was a conversation you had before. You know, we elect spouses of school teachers to school boards all the time. And the reason we do that is everybody knows that in the county, that that's who they're related to. And but because they know something about the school, or they'll have the ear of the teachers or something like that. But it's a known fact. And so I think you need to look at this law in a manner that still allows the voters to have their elected representatives consider matters that come before them. And Mr. Chairman and Co-Chairman, thank you for allowing me to make these comments that I have, and I stand for any questions that anybody might have.
Mr. Barron, I'll ask one back on the nepotism section, which began on page 6, line 10. You know, a lot of the counties in the state, like yours and like mine, they're under 10,000 people. Everybody's related. Do we risk stepping on the toes of these, all the little counties like that, where sometimes it's hard to fill a position? And, you know, people do hire their sister or their cousin or give them some position. I just wondered if we've kind of overreached it, and that it's quite a different matter in Natrona County than it is in Crook or Platte.
Mr. Chairman, Co-Chairman Kirkbride and Co-Chairman Nethertott, you know, that's a decision, that's a political decision. In our case, county, roughly 7,500 people, there's was a historic practice of elected officials hiring spouses long-term, and people knew that fact, and they kept re-electing them. And so the people have there's a political side of this thing that the people can take care of it if they choose to do so. In that, what all this statute will do is just, they can't hire their family on that. So I think and this has been the law generally. This has pretty much been the law since 1996 anyway. It just, when this law was passed. And the only issue that I see with this law is that people try to work around it. This has been my experience. And then when it doesn't apply to county employees, or say, for example, a manager of a county department or something like that, of them hiring their family members. And that's one of the reasons for the expansion, because everybody thinks it applies to everybody in the government. And the fact of the matter is that it doesn't.
Okay, Madam Co-Chairman, did you have something? Right, way back?
Just briefly, if I can, I just wanted to thank Mr. Barron for his work on this. Really great efforts, great information, and I appreciate it. I think it's very helpful to the committee.
Representative Gray.
Thank you, Mr. Chairman. Mr. Barron, I was really disturbed by, appreciate your work, really disturbed by what you said about the larceny statute, that we've got a problem, and was wondering if you could elaborate on what the Houston, we have a problem moment is. We've been churning out a lot of legislation, and in this committee, I'm very concerned about the number, and I think that was one where, you know, we got to get the wording right on these. And so what's the problem here?
Okay, well,
Mr. Barron.
Mr. Chairman, Co-Chairman Kirkbride and Co-Chairman Nethercott. The problem is, and I think this could be addressed by there were some attorneys that worked on this from the jury instruction, criminal pattern jury instructions, which led to that. One of the things in the statute, the way it's worded, no, I don't have that book in front of me, but there's, let me pull it up here real quick.
Mr. Co-Chairman, if I may.
Madam Co-Chairman.
So we're on the bill that we passed last year on the comprehensive changes to theft. Is that right? And the criminal pattern jury instruction committee, made up of some prosecutors, found and what they believe is an error. Is that right, Mr. Barron? And they're working on that. And I think they've communicated that to many members of the legislature. And so at least I'm aware of what their concern is. So, I mean, is that what we're working on right now, or are we on this bill draft, I guess? And it's not that I don't care about the issue. It's just maybe dealing with that at the right time.
Well, I'm asking a question off of
Representative Gray.
something. I'm asking a question off of something that was said, and I think it's instructive in terms of the number of things that you know, the number of bills has just been astronomical, and I've been concerned about it, and I want to make sure we're getting all these right, and I think it's a judiciary topic. I mean, so I just wanted to ask about what the issue is, and it hasn't been communicated to me. So I would like to understand that, and if we've got a problem with the larceny statute, I mean, I think that's definitely a judiciary committee topic. So thank you.
All right. Any further comments, Mr. Barron?
Co-Chairman Kirkbride, so do I answer the question or don't? Or don't I answer the question?
Well, I'd say answer it.
Co-Chairman Kirkbride and Co-Chairman Nethercott, I don't know exactly what's going on in the background with this. I'm sure the conversation was we need to talk to somebody in the legislature and correct it. It just seems to me there's under subpart A, there's it says, and he, subpart I, subpart double I, and subpart triple I. And on the floor, in looking through all the records, it seems like on the floor that there was a subpart 4 that was included on the statute, and that was stricken on the floor. And when that was stricken, they also struck the or right after subpart 3, A3, and didn't add it back into subpart 2. Clearly the intent was that it was one of those 4 alternatives, and without that or being in there, it appears that it's arguable that all 3 of those things apply now to not the entire statute, but a portion of the statute, one of the alternative charging matters within that. But that's what I observed anyway. And it's been pointed out by defense attorneys to us as well, so.
Well, Representative, Madam Co-Chairman, and then we'll go to Representative Jennings.
Just for a matter of, I think, ease for LSO and rules of procedure, I think we could continue this conversation after we maybe deal with this bill draft in the event the committee wants to take action on this topic, or maybe wrap out this bill draft and then deal with that piece. I think what we heard Mr. Barron say is it wasn't a Judiciary Committee drafting issue. It was an amendment that occurred on the floor that I think probably inadvertently deleted the word "or." And then it got passed through in the heat of the end of a budget session. And so the remedy to the situation is to add the word "or" back in, and all our hearts are resolved. And so it was a non-judiciary error. And I just think that's important for both our LSO and for this committee's work as a result of what happened there.
Representative Jennings.
Thank you, Mr. Chairman. I'd like to ask Mr. Barron a question that Mr. Merrill kind of brought up. And in his conversation, there was some talk about the private side of this, but not as much of the public interest, you know, of a person who maybe in their private business might be gaining. But I'd like to get Mr. Barron's opinion of this. It seems like the public interest might be even more important to spell out, like that our current laws cover a lot of the private entities. But if I could hear him speak a little more to the public side of this, you know, the teachers are, you know, it's been my experience that as you look at some of those things, the teacher issue is what's brought up the most, but maybe there's other things, the state lands, things of that nature. Could he speak to that just a little bit more? What?
Mr. Barron.
Co-Chairman Kirkbride and Co-Chairman Nethercott, Representative Jennings. You know, I guess the other thing that might come up there, I don't exactly understand the difference between public and what you're saying with public benefit or versus private. It appears that the law is to prevent you from using your position as a public official for private benefit. Is what it would seem the law's intent is. And I guess the other things that might come from the legislature is anything as a tax increase, a tax decrease, that might amount to something. That can cover anything from oil and gas interest to you name it. Anything that the government deals with as far as taxes go could have some interest there. I don't know that I'm answering your question, Representative Jennings. If you could clarify maybe some more for me.
Representative Jennings.
Thank you, Mr. Chairman. Well, I was just referring to your thoughts on when Mr. Merrill was speaking. It seemed like that it was more like we were going to go after it if somebody held